Suppose you're remarried and you tell your spouse, I'm leaving everything to you. I trust you to take care of my children after I'm gone. That may be a completely sincere family understanding, but does it actually protect your children's inheritance? Usually the answer is no. Leaving everything outright to a surviving spouse may provide security for that spouse, but it doesn't guarantee that children from an earlier relationship will receive anything later. I'm Harvey Cox, a Texas estate planning attorney. In this video, I'm going to explain three ways estate plans commonly fail in second marriages. The first is relying on an unwritten promise. The second is assuming that the will controls every asset. The third is failing to make a specific plan for the home. This isn't about distrusting your spouse. It's about making sure the legal plan carries out the intentions both of you have today. Let's consider Robert and Linda. Robert is 68, Linda is 64. They've been married for 9 years. Robert has two adult daughters from his first marriage. Linda has an adult son. Robert wants Linda to be financially secure if he dies first. His will leaves everything to Linda, and his retirement account also names Linda as beneficiary. Robert believes Linda will use whatever she needs during her lifetime and then divide what remains among all three children. Linda may fully intend to do exactly what Robert expects, but once she receives the property outright, she generally controls it. She may spend it, sell it, reinvest it, change beneficiary designations, make gifts, or leave whatever remains under a later estate plan. The solid arrow from Robert to Linda represents the part of the plan that is legally established. Robert's property passes to Linda. The dotted arrow from Linda to the children represents Robert's expectation that whatever remains will later pass to them. But that second transfer is not required by the current arrangement. Nothing in Robert's will or beneficiary designation requires Linda to preserve an inheritance for his daughters. The issue is not whether Linda can be trusted. The issue is whether Robert's legal plan carries out both of his goals. That doesn't mean Linda acted unfairly or broke a promise. Life may look very different 10 or 15 years later. She may need the money for living expenses, health care, home repairs, or long-term care. She may need to sell the home or move somewhere smaller. Her son may face a financial emergency. She may revise her estate plan or later remarry. Any of those decisions may be reasonable, but they could still defeat Robert's original expectation that his daughters would eventually receive part of the estate. The problem with Robert's plan isn't Linda's character. The problem is that the plan protects only one of Robert's two goals. It provides for Linda, but it doesn't create binding protection for his daughters. An estate plan should answer a clear question. Should the surviving spouse receive the property without restriction, or should some property be managed in a way that supports the spouse while preserving whatever remains for specified beneficiaries? Either choice may be reasonable. The choice should be intentional and reflected in the documents. The second mistake is believing that a will controls every asset. It doesn't. A will generally controls property that passes through the probate estate, but many valuable assets may pass under separate contracts, beneficiary forms, or ownership arrangements. These may include retirement accounts, life insurance, payable on death accounts, transfer on death arrangements, and property covered by survivorship agreements. Suppose Robert's will contains carefully drafted provisions for Linda and his daughters, but his retirement account names Linda as the outright beneficiary. The retirement plan administrator generally follows the beneficiary designation, not the will. That means a person can unintentionally have several different estate plans operating at the same time. One plan may be contained in the will, a second may be in a retirement account beneficiary form, a third may be built into the deed to the home. A fourth may exist in a survivorship agreement or transfer on death designation. Changing only one of those documents may not change the others. The answer isn't simply to sign a longer will. The documents, titles, and beneficiary designations have to be reviewed together and made to point in the same direction. The third mistake is failing to make a specific plan for the home. Robert bought the home before marrying Linda. Community funds have also been used during the marriage for mortgage payments, maintenance, and improvements. Robert wants Linda to remain in the home if he dies first. He also wants the home, or part of its value, eventually to benefit his daughters. Those are separate objectives. A useful plan should address practical questions. How long may Linda remain in the home? Who pays the property taxes, insurance, mortgage, and major repairs? May the home be sold if Linda needs to move? What happens to the sale proceeds? And who receives the property after Linda dies? Leaving those questions unanswered can create uncertainty even when everyone is acting reasonably. Texas intestacy law adds another layer. Texas is a community property state, but that doesn't mean a surviving spouse always receives all community property or automatically receives one half of every asset. The result depends on the family structure and the character of the property. For example, if a married Texan dies without a will and leaves descendants who are not also descendants of the surviving spouse, the deceased spouse's interest in community property generally passes to the deceased spouse's descendants. That can leave the surviving spouse and the deceased spouse's children with interests in the same property. Separate property follows different rules, and separate real property and separate personal property require different analysis. Homestead rights must also be distinguished from ownership. A surviving spouse may have important rights to occupy the family home even when the spouse doesn't own the entire property, but the right to remain in the home, legal title, responsibility for expenses, the right to sell, and the right to receive the property later are separate issues. That is why statements such as the spouse gets half or the children inherit the house are often incomplete. The answer depends on the family relationships, the character of the property, the title documents, and the terms of the estate plan. There isn't one plan that fits every second marriage. Some couples decide that the surviving spouse should receive everything outright. That may be appropriate for their circumstances. Other families use a more structured arrangement. For example, a properly drafted and funded trust may permit property to be used for the surviving spouse during life while directing the remaining property to the deceased spouse's children later. The trust might provide income, access to funds for stated purposes, or the right to live in a home. It might also explain who manages the property and what happens if the home is sold. But the word trust alone doesn't fix the problem. The documents, funding, deeds, titles, and beneficiary designations must all work together. If you're remarried or considering remarriage, review 5 parts of your current plan. Look at your will or trust. Review every beneficiary designation. Check the deeds to your real estate and the ownership of your financial accounts. Determine whether the documents contain clear instructions for the home, and identify the beneficiaries each spouse actually intends to protect. Then ask 2 separate questions. First, what does my spouse need if I die first? Second, what do I intend my children or other beneficiaries to receive, and when? Compare those answers with what the documents and asset arrangements actually provide. Don't assume that a family understanding written nowhere will become legally enforceable later. This video provides general information and isn't legal advice for a particular person or family. Second marriage planning depends on the assets involved, the family relationships, the way property is owned, and the language of the documents. If you'd like to review whether your current plan protects both your spouse and your children, you can schedule a consultation with me at harveycox.com. I'm Harvey Cox. Thank you for watching the Legacy Docket.